How to challenge or contest a will. My name is Daniel Winter and I am a solicitor in the Wills and Probate Dispute Resolution team at Nockolds Solicitors. One of the topics on which we are most frequently asked to advise clients is how to challenge or defend the validity of a will. To take legal action in this area was once quite a rarity, but in recent years there have been a surge of claims. The purpose of this video is to provide some basic information about how to challenge a will and the initial steps anyone who is considering this should take. It's by no means a full or comprehensive guide to what is a complex and changing area of the law, and you should seek professional legal advice on any specific issues. So the first step is to consider the reasons why a will might not be valid. There are four main reasons or grounds. The first is in making the will, certain required legal formalities might not have been followed. Was the will made in writing? Was it made by somebody over the age of 18? And was it signed by the maker in the presence of two witnesses? If not, there's a strong indication the will may not be valid. Secondly, a will is not valid if the person making it did not have sufficient mental capacity at the time. This is probably the most common reason why wills are overturned. To be valid, the person making the will must understand what they are doing. For example, if the maker of the will was suffering from a condition that affected his or her mind, such as dementia or Alzheimer's, there is an indication of a reason to doubt the will's validity. Thirdly, if the person making the will did not know what was contained in it or agree with its content, it is invalid. For example, did the person making the will have problems with their sight, reading or hearing? Lastly, ask yourself, are there any suspicious circumstances concerning the signing of the will? If the maker of the will was placed under undue pressure by somebody else to write their will in a certain way, it's not valid. Do the signatures look correct? There are occasional instances of forgery. So if you think there may be a reason why the will might not be valid, what do you do next? Well, before you do anything, you need to consider what would be the outcome if you challenged the will successfully. There is no point beginning what might be a long and stressful process that might not lead to any better outcome for you. If your challenge to the will is successful, the last will of the deceased will be declared invalid. This means that the previous valid will in line will take its place. Do you benefit more under the previous will? If the will that you successfully challenge was the deceased's only will, then how that person's legal estate is distributed will be determined by the laws of intestacy. So you may or may not benefit depending on how you are related to the deceased and the presence of surviving relatives. So this means that investigations should really be undertaken before you commence a validity claim. At the same time, you should also take steps to preserve the deceased's estate. When somebody has died, their personal representatives or executors will want to gather in the person's assets, sell any shares, sell any properties, and then distribute the proceeds according to the will. They can only do this once they've applied for and obtained a grant from the probate registry. At the same time, you should also take steps to preserve the deceased's estate. When somebody has died, their personal representatives or executors will want to gather in the person's assets, sell any shares and properties, and then distribute the proceeds of sale according to the will. They can only do this once they have applied for and obtained a grant from the probate registry. There is a mechanism that allows you to stop the personal representatives from obtaining this grant. This is called the caveat procedure. If you want to challenge a will, you should apply to enter a caveat at the probate registry as soon as possible. It's a relatively simple and inexpensive procedure, and there's some good guidance on how to do this available on the Probate Service website. After these initial stages, it will probably require great efforts to resolve the claim, usually involving legal argument and skillful negotiation. Whilst most cases tend to be resolved without court proceedings, claims occasionally do end up in court for trial. For these reasons, I recommend that you seek professional legal advice from the earliest possible moment, as there is often a lot at stake. If you have a potential claim you would like to discuss, or indeed are facing a claim and wish to defend it, please feel free to get in touch using the contact details that appear on the screen. I can reassure you there will be no charge for the initial discussion. At Nockolds we have a wealth of experience and success in this area of law. Please feel free to view our web pages and articles for more information about our team and our services.